Is there two-tier justice in this country? Two very similar cases with two very different results. One, an encouragement of violent disorder, led to a not guilty verdict by a jury. The other, incitement to racial hatred, led to a 31-month prison sentence from a judge following a guilty plea. Both these offences were ones that involved no physical action. They were ideas, they were thoughts, they were speech in its broadest sense, rather than anybody taking a knife or a gun or even a fist and hitting somebody. They were both speeches of thought and word rather than of action. And one went free, the other led to a long prison sentence. Is this the two-tier justice that some are saying? Or is there another problem, another issue that we need to think about? Let's look at the two cases in turn. First of all, the well-known case of Lucy Connelly. What did she do? She tweeted that she would not mind if illegal immigrants in their hotels were burnt down. This was a terrible thing to say, an unpleasant thing to say, a vile thing to say. But she didn't actually say she wanted to burn them down, and she didn't tell other people that they should go and do it. She merely said that she wouldn't mind if they did. 31 months in prison for this, first-time offender, otherwise of good character, a tweet that she had deleted subsequently. But the courts not only held that that was the right sentence in the first place, but the appeal court held that this was not manifestly unreasonable. So a double hit from the judicial system against Lucy Connelly. Then you have Ricky Jones. What did Ricky Jones say? Well, he said that he thought neo-Nazis should have their throats slit, and emphasised it by making a slitting sign across his own throat. For this, he was prosecuted and found not guilty by a jury. This is important because the jury system is at the centre of all our freedoms. Immediately behind me is a facsimile copy, I'm sorry it's not the original, of the Magna Carta. And we all know that it is the Magna Carta 1215, sealed by King John at Runnymede, that says no free man shall be taken or dispossessed of his lands except by the trial of his peers, and the rule of law is fundamentally underpinned by Magna Carta. We have that right to trial by jury. And we should take confidence in this. We should oddly take confidence in the Ricky Jones case because a jury found that words could be explained and they could be contextualized and preserve freedom of speech. The jury is the protector against the tyranny of the blob, which doesn't like you to think or say things that it does not approve of. It doesn't want you to cause difficulties. It doesn't like the freedom that the internet brings. It doesn't like the freedom that is caused by videos going viral. And Ricky Jones's video went viral. Now, I'm not advocating what he said. I'm not supporting what he said. I don't think it was a right thing to say. But a jury decided that he had the right to say it, and that in so doing he was not actually really and genuinely advocating violence. He wasn't really asking for people's throats to be slit. He was making a point, a political point, and he argued in his defence that it was in response to some neo-Nazis who'd been found with razors, and he hoped that they slit their own throats. And really interestingly, the jury only took half an hour to come to this verdict. I've done jury service. A jury that comes to a conclusion that quickly must have thought the case against him was pretty weak, pretty ropey. That leaves Lucy Connelly, because Lucy Connelly could have had a jury trial, I think. You can't always be absolutely certain, but almost certainly she was entitled to a jury trial, depending on the precise charge that would have been brought, if that's what she was electing for. And I think a jury would have acquitted her too. But huge pressure was brought to bear on her to plead guilty and get it over with. And this is where the problem of two-tier justice comes. It is not the jury. The jury underpins all our freedoms, and juries are entitled to make decisions that you may think are odd. I see the leading Tory politician has said that it's a perverse verdict. Well, that's the glory of jury trials. They don't do what they're told by the elite. They don't obey orders from the judges. They come to their own conclusions. And very often they favour freedom against the powerful prosecutor going for somebody who's merely said something a bit disagreeable. So Lucy Connelly pleaded guilty. Why did she plead guilty? Because she was being threatened with a long term on remand, a backlog of cases, and the government had interfered with the justice system. And this is really interesting because whilst I was a Member of Parliament, new rules came in to say that MPs weren't allowed to interfere in any way with the justice system. We couldn't even write to a judge to say that a constituent's case was taking too long or a victim was concerned. I got a very sniffy letter from the Somerset coroner, who's completely incompetent, or was at the time, wasn't getting on with cases. Constituent wanted to know about a case in which a family member was involved and obviously died. And the coroner was so sniffy and saying the fact that we're useless isn't any business of a Member of Parliament. It is clear that politicians are not meant to interfere in the routine administration of justice. But following Southport, they were. The Prime Minister, Sir Keir Starmer, got up and said that things would happen quickly, and they did. The courts ran to the tune, danced to the tune of their political leaders. Anyone involved was prosecuted extremely quickly, and the book was thrown at them. The prosecutors and the courts involved themselves in expediting imposition of penalties because the government, the executive, had said so. And this cuts at the heart of the independence of our judicial system. It was really a very dangerous approach for the government to take, but even more ridiculous that the prosecutors and the judiciary went along with it when they are both meant to be independent. And this is where Lucy Connelly got caught up. She got caught in this vice, a political vice, which the judges were dancing along to. And that's what has led people to think that if you make left-wing comments, you'll be fine. So you call for neo-Nazis to have their throats slit, that's fine. But if you make what may be seen as right-wing comments, you're going to be in trouble. And justice should be fair for all. But as we make that argument for justice being fair for all, which it should be, and that people who make comments of this kind, people who inspire racial hatred or encourage violence, are not unreasonably answerable for those comments. I think in both cases there was at least a question to be asked about whether it was within the bounds of the law, but it should be done on a fair and just basis. And what underpins all our rights is the jury trial, because it would not convict. And those of us who are conservatives should be pleased that a jury has not convicted on a trial for what somebody has said, even if what he has said is very unpleasant, because it is a reminder that juries protect our freedoms. Now, this is really important, because Leveson, that man, that dangerous man who hated the freedom of the press, wrote the Leveson report that wanted to see the press put under the control of the state. He has written a report wanting to see jury trial limited. And if jury trial is limited, then your freedom, your liberty is limited, and your ability to exercise your right to free speech risks being undermined, because we see with Lucy Connelly what happens when the state is in a tiz, when the state is worried about something. It puts enormous pressure on, and the judiciary goes along with it. They cease to maintain their high-minded independence. They go along with what the government wants. That's what they did with Lucy Connelly. The jury system wouldn't do that for Mr. Jones. For Mr. Jones, the jury system said this case is ridiculous. Frankly, a half-hour deliberation shows that they thought the prosecution was contemptible, not a serious effort to bring a crime to book, but a waste of everybody's time. So we should back the jury system. We should try and do our best to make sure that it survives the Leveson onslaught, because in the name of efficiency, the government wants to reduce it and control it. And the judges, who of course think they get things right, want more power for the judges. But actually, the judges have caused us a lot of problems in recent years by their excessive enthusiasm for human rights laws that have given them power over Parliament, for the ridiculous Lady Hale, who was Supreme Court President, ruled consistently against the government and noticeably voted against all Rishi Sunak's immigration policies. These judges have taken too much power, and the government wants them to have more. The juries hold them back. So look at that great document behind me. It's 810 years since Magna Carta was agreed. It is the great support, the great underpinning, the great foundation of our constitutional liberty. And that is that however powerful the government, however powerful the judges, it is 12 of your fellow citizens who will decide whether you have committed an offence. And that protects us from offences that the government wishes to enforce, but which the people of the country don't think are right. As I say, I think Lucy Connelly would not have been found guilty by a jury. They might not have liked what she said any more than I do, but they wouldn't have wanted her to spend 31 months in prison. That's what's happened to Ricky Jones. The jury decision is not two-tier justice. What happened a year ago is two-tier Keir has a lot to answer for, but it's the jury system that protects us.